The first days of Prince Harry's appearance in court have ignited an extraordinary wave of commentary, criticism, and speculation. What was expected to be a sober legal battle over alleged press misconduct has instead evolved into a broader public debate about Harry himself, his temperament, his strategy, his emotional state, and the wider consequences of his long-running war with the British press. Observers watching the proceedings have not merely focused on the legal arguments. Instead, much of the attention has centered on Harry's behavior in the witness box, how he answers questions, how he reacts to opposing counsel, and how he presents himself in a formal legal environment that demands discipline, restraint, and precision. To some commentators, what they are seeing is not the calm, purposeful figure of a man seeking justice, but a visibly agitated individual struggling to adapt to the strict conventions of courtroom testimony. A courtroom is not a stage one of. The sharpest criticisms leveled at Prince Harry's performance so far is his apparent inability, or unwillingness, to accept the limited role of a witness. In a courtroom, the witness is not there to argue the case, shape the narrative, or reprimand the opposing side. The task is far simpler and far narrower: listen carefully, answer the question asked, and allow legal counsel to do the rest. Yet critics argue that Harry repeatedly departs from this model. Rather than offering concise responses, yes, no, or I don't know, he has a tendency to expand, explain, and editorialize. At times, he appears to drift into commentary about how journalists should behave, how the media ought to conduct itself, and how the system itself is flawed. From a legal perspective, this approach is counterproductive. Courts are not persuaded by speeches from the witness stand. Judges are concerned with evidence, relevance, and procedure. When a witness attempts to lecture the courtroom, it risks irritating the judge and weakening the credibility of the testimony. In fact, during one tense exchange, the judge was forced to intervene, reminding Harry that it was not his role to argue with opposing counsel. That intervention alone spoke volumes. Judges rarely step in unless they feel control of the process is slipping. Clashing with counsel. Perhaps the most damaging moments so far have come when Harry appeared to engage directly with the lawyer representing the Daily Mail and Mail on Sunday. Instead of responding to questions, he challenged their framing, disputed their intent, and pushed back in ways that bordered on confrontation. Legal experts watching from the sidelines were quick to point out how unusual this is. A witness who becomes combative risks appearing defensive, emotionally driven, or unprepared. Worse still, it creates the impression that the witness believes the court itself is unfair, an impression that can subtly undermine the judge's perception. What puzzled many observers was not merely Harry's behavior, but the apparent absence of firm guidance from his own legal team. In high-stakes cases, witnesses are usually drilled extensively. They are coached to remain calm, to avoid volunteering information, and to resist the urge to argue. When that discipline breaks down, questions inevitably arise about preparation. Why? Critics ask, has Harry not been more carefully guided? Why does he continue to answer expansively when brevity would serve him better? To some, it appears as though his lawyers have either underestimated his emotional volatility or failed to rein it in. Absolute misery, a claim under scrutiny. One of the most widely discussed statements to emerge from Harry's testimony is his assertion that Meghan Markle lived in absolute misery due to media treatment. Emotionally, it is a powerful claim. Legally, however, it opens a door to scrutiny. Commentators were quick to point out a glaring contradiction. Public statements made by Meghan herself in recent years paint a very different picture. In interviews and public appearances, she has described periods of her life as the happiest she has ever known, expressing gratitude, fulfillment, and optimism. This contradiction raises uncomfortable questions. If Meghan publicly stated she was happy, how does that align with Harry's courtroom depiction of her life as unbearable? Was he speaking emotionally rather than factually? Was he referring to a different time period? Or is there a deeper inconsistency between their narratives? In court, consistency matters. When statements appear to conflict with the public record, opposing counsel can exploit those gaps. Even if the emotional truth feels real to the witness, the legal truth must be supported by evidence. To critics, Harry's statement seemed careless, an emotional outburst rather than a carefully framed assertion. Some went further, arguing that such claims risk undermining the broader credibility of the case. The weight of the past. Another striking feature of Harry's testimony is his repeated return to events that occurred many years ago. Incidents involving former relationships, long-past media encounters, and grievances dating back more than a decade have resurfaced with fresh intensity. While it is true that long-term patterns of behavior can be relevant in legal cases, there is a fine line between establishing context and appearing trapped in the past. Observers noted that references to events from the mid-2000s, particularly those involving his former girlfriend, Chelsea Davy, seemed to carry an emotional charge that felt unresolved. To some, this suggested that Harry is still processing old wounds. To others, it raised doubts about relevance. Why, they asked, should incidents from nearly 20 years ago dominate a modern legal battle? There is also a human dimension to this. Chelsea Davy has long since moved on, building a life away from royal drama. Dragging her name, even indirectly, back into headlines strikes some as unnecessary and unfair. ### Emotional exposure in the witness box. Beyond legal tactics, there is an undeniable emotional rawness to Harry's presence in court. At times, he appears tense, defensive, and visibly frustrated. Commentators have described him as angry, bitter, and consumed by resentment. This emotional exposure cuts both ways. On one hand, it humanizes him. Viewers can see a man who genuinely feels wronged, who believes his family has suffered, and who is desperate to reclaim a sense of justice. On the other hand, unchecked emotion can appear unstable, especially in a setting that prizes composure. Several observers expressed concern about his mental well-being. They described him as lost, unmoored, and uncertain of his role, no longer fully royal, not entirely private, and perpetually at war with institutions he once depended on. The courtroom, in this sense, becomes a mirror reflecting deeper struggles. Harry is not simply fighting a newspaper. He is grappling with identity, legacy, and unresolved anger stretching back to his youth. A self-appointed leader, another point of contention is Harry's apparent tendency to position himself as a spokesperson or leader for the other claimants involved in the case. Alongside him are high-profile figures including Elton John and Liz Hurley, each with their own grievances and legal representation, yet Harry often speaks as though he is acting on behalf of the group, guiding, instructing, and framing the case as a collective moral crusade. Critics argue this is misguided. In legal terms, each claimant stands alone. One person does not speak for the others. This self-appointed leadership role feeds into a broader perception that Harry believes himself uniquely qualified to define the moral stakes of the case. To detractors, this comes across as arrogance rather than advocacy. The court's patient judges are trained to remain impartial, but they are also human. Repeatedly straying from direct answers, challenging counsel, and delivering unsolicited commentary can test that patience. Observers noted moments where the judge appeared irritated, forced to redirect proceedings back to proper legal channels. Such moments matter. While judges do not rule based on emotion, their perception of a witness's reliability and discipline can subtly influence how testimony is weighed. As the case unfolds, the question is no longer simply whether unlawful information gathering occurred. It is whether Prince Harry can adapt his approach, restrain his emotions, and present himself as a credible, disciplined witness rather than a crusader driven by personal grievance. As the trial progresses, attention is shifting away from isolated courtroom moments toward the broader consequences facing Prince Harry. What began as a legal challenge against alleged press misconduct is increasingly being interpreted as a referendum on Harry's judgment, stability, and future direction. The implications stretch far beyond the courtroom walls. Reputation on the line. Prince Harry entered this trial presenting himself as a principled figure standing up to powerful media institutions. However, his conduct in court has complicated that narrative. Instead of appearing composed and authoritative, he has, at times, come across as reactive and emotionally driven. Reputation is not decided by legal outcomes alone. Public perception is shaped by demeanor, clarity, and consistency. Critics argue that Harry's tendency to argue with lawyers, revisit decades-old grievances, and make sweeping claims has weakened his standing. Rather than being seen as a disciplined campaigner for privacy rights, he risks being portrayed as a man unable to let go of past wounds. This perception could linger long after the verdict is delivered. Financial stakes and legal risk. The financial consequences of this case are potentially enormous. Legal analysts have warned that if Harry and the other claimants lose, the cost liabilities could reach tens of millions of pounds. Figures approaching £39 million have been discussed in commentary, a staggering sum even for someone of Harry's background. This risk is not theoretical. British courts are unforgiving when it comes to costs in failed civil litigation, particularly when cases are prolonged and complex. Harry has already invested heavily in legal battles across multiple cases, raising questions about sustainability for someone who stepped away from royal funding to pursue financial independence. These risks are significant. Losing this case could place long-term pressure on income streams, investments, and future legal strategies. Strained alliances. Another underexplored consequence is the potential strain on relationships with the other claimants. While figures such as Elton John and Liz Hurley have their own reasons for joining the case, Harry's dominant presence risks overshadowing their individual claims. If the case fails, resentment could follow. Other claimants may quietly question whether Harry's approach, his public profile, his emotional testimony, his confrontational style, made the case harder rather than stronger. Legal coalitions are fragile. When one figure becomes the public face, responsibility, fair or not, often follows. A marriage under pressure. Beyond law and money lies the question many observers are asking quietly: what does this mean for Harry's marriage? Harry repeatedly frames his legal battles as acts of protection, protecting Meghan, protecting his children, protecting his family's future. Yet critics suggest that this relentless focus on past trauma may be creating new strains rather than resolving old ones. Public contradictions between Harry's statements and Meghan's past comments about happiness have fueled speculation. Are they describing different emotional realities? Different time periods? Or are their narratives simply out of sync? Marriage thrives on shared perspective. When one partner remains locked in conflict while the other seeks reinvention and forward motion, tension can follow. Identity crisis. Perhaps the most profound issue exposed by this trial is Harry's unresolved identity crisis. He is no longer a working royal, yet he continues to define himself in opposition to royal institutions. He seeks privacy yet remains deeply engaged with public confrontation. He criticizes hierarchy, yet often positions himself as a moral authority. This contradiction plays out vividly in court. At times, Harry behaves as though he is still a senior figure accustomed to deference. At other moments, he appears adrift, uncertain of his role or influence. Observers note that he seems caught between worlds, unable to fully return to royal life, yet uncomfortable in the ordinary anonymity he claims to desire. Old grievances, new battleground. Harry's repeated references to events from the mid-2000s have struck many as disproportionate. While early experiences undoubtedly shaped his distrust of the press, revisiting them in granular detail risks appearing obsessive. The mention of former relationships, long-past media encounters, and perceived slights suggests a man still negotiating emotional terrain he never fully processed. Critics argue that this backward gaze undermines his claim to be fighting for the future. Courts are interested in patterns, not nostalgia. The more Harry dwells on the distant past, the easier it becomes for opponents to argue irrelevance. Leadership without authority. Harry's tendency to position himself as a leader within the claimant group reflects a broader pattern seen since his departure from royal duties. He often assumes the role of spokesperson, strategist, and moral compass, even when that role has not been formally granted. In court, this manifests as a belief that he must explain, guide, and correct others. Yet legally, he holds no authority over fellow claimants. Each case stands on its own merits. This mismatch between perceived and actual authority feeds criticism that Harry overestimates his influence while underestimating institutional boundaries. The judge's perspective. While judges rarely reveal personal views, their management of proceedings offers subtle clues. Repeated reminders to stay focused, answer concisely, and refrain from argument suggest concern over Harry's approach. Judicial irritation does not equal judicial bias, but it does signal that patience is finite. A witness who resists structure risks diminishing the impact of their own testimony. In high-profile cases, composure is currency. A mental and emotional toll. Several commentators have expressed concern for Harry's mental well-being. Descriptions such as lost, angry, and unsettled recur in analysis. While such assessments are speculative, they point to a broader unease about his trajectory. Harry has spoken openly about trauma, therapy, and emotional struggle in the past. The courtroom, however, is a blunt instrument. It offers judgment, not healing. By placing deeply personal pain into an adversarial environment, Harry may be intensifying the very distress he hopes to resolve. What happens if he loses? If the court rules against Harry, the consequences will be immediate and lasting. Financial liability, reputational damage, and weakened leverage in future cases would follow more subtly. A loss could reinforce a narrative that Harry's war with the media is driven more by personal grievance than legal merit. That perception could erode public sympathy and limit future support, yet even victory would not guarantee vindication. Winning on technical grounds would not erase the impression left by weeks of emotional testimony. The long shadow. Regardless of outcome, this trial will cast a long shadow over Harry's public life. It crystallizes years of conflict into a single, defining episode. For Harry, the choice ahead is stark. He can continue to fight, escalate, and relitigate the past, or he can recalibrate, step back, and redefine himself beyond opposition. The courtroom has exposed not only alleged media misconduct, but a man at a crossroads. Whether Prince Harry emerges strengthened or diminished will depend less on the verdict than on what he chooses to do when the doors of the court finally close.